Question 331. For the purposes of appraisal, the key element of value falls under two categories: value in use and A. Value in land, B. Value index, C. Value in exchange, D. Value added tax. Correct answer is C. Value in exchange. The key element of value, for appraisal purposes, falls under two main categories: value in use and value in exchange. Value in use refers to the specific value a property has for a particular user or in a specific use. It considers the benefits the property provides to its current owner or for a specific business operation. Value in exchange refers to the value of a property in the open market, representing the price it would likely fetch if sold to a typical buyer under normal market conditions. This is the primary focus of most real estate appraisals. Question 332. A lease that a lessee subleases to another party who is the actual user of the property is called an A. Operating lease, B. Assignment, C. Estate for years, D. Novation. Correct answer is A. Operating lease. An assignment is a transfer of the entire leasehold interest by the original tenant to a new tenant. The assignee becomes directly responsible to the landlord. Estate for years refers to a lease with a definite beginning and ending date. While the original lease might be an estate for years, this term doesn't specifically describe the situation of a subleased property with an actual user. Novation is the substitution of a new contract for an old one, or the substitution of a new party for an old one with the agreement of all parties involved. This would typically involve the landlord releasing the original tenant from the lease and creating a new lease with the subtenant, which isn't necessarily the case in a standard sublease. While operating lease has a specific meaning in accounting and equipment leasing, in the context of a lessee subleasing property, it describes the primary lease under which the original tenant, lessee, holds the property and then grants a sublease to a subtenant, the actual user. The original lease is operating, in the sense that it's the active lease from which the sublease originates. Question 333. Which of the following best describes a trust as a form of property ownership? A. Title is held by the trustee on the beneficiary's behalf, B. Title remains with the original owner who releases it to the beneficiary on a certain date. C. Title is entrusted to a beneficiary if the probate court agrees, D. None of the above. Correct answer is A. Title is held by the trustee on the beneficiary's behalf. A trust involves three main parties: 1. Trustor, or settlor, the person who creates the trust and transfers property into it. 2. Trustee, the person or entity who holds legal title to the trust property and manages it according to the terms of the trust document for the benefit of the beneficiary. 3. Beneficiary, the person or entity who benefits from the trust property. The key characteristic of a trust is the separation of legal and equitable title. The trustee holds legal title, meaning they have the formal ownership and the power to manage the assets. However, they must do so for the benefit of the beneficiary, who holds equitable title, meaning they have the right to enjoy the benefits and use of the trust property. Question 334. If a real property title that is encumbered by a trust deed is transferred through a sale, it is necessary to A. Have the grantor provide the delivery of the deed, B. Repay the trust deed balance in full, C. Attain the permission of the lender, D. Real property encumbered by a trust deed cannot be transferred. Correct answer is A. Have the grantor provide the delivery of the deed. The fundamental legal action required for the transfer of real property title, even when the property is encumbered by a trust deed, is the delivery of a valid deed from the grantor, the seller, to the grantee, the buyer. This act signifies the formal conveyance of ownership rights from one party to the other. Without a properly executed and delivered deed, the legal transfer of title does not occur, regardless of any existing liens or agreements. While the presence of a trust deed, a common security instrument for real estate loans, does not prevent the transfer of property ownership, it does introduce complexities that must be addressed during the sale process. The existing loan secured by the trust deed remains a lien on the property, and the buyer will essentially take title subject to this encumbrance. The manner in which this existing loan is handled is a matter of negotiation between the buyer and seller. Options include the seller paying off the loan in full from the sale proceeds, the buyer assuming the existing loan, which often requires lender approval, or the buyer purchasing the property, subject to the existing loan, meaning they acknowledge and take on the responsibility of the debt without formally assuming it. It's important to note that most trust deeds contain a due on sale clause, which grants the lender the option to accelerate the loan and demand full repayment if the property is sold or transferred without their consent. While this clause doesn't legally prevent the title transfer, it can significantly impact the transaction and often necessitates communication and agreement with the lender. Therefore, while the physical act of transferring title hinges on deed delivery, the practicalities of selling encumbered property involve addressing the existing financing through repayment, assumption, or other negotiated arrangements. Question 335. An easement appurtenant exists between two separately owned parcels of property. Bart owns the dominant tenements and Dave owns the servient tenement. If Bart sells his parcel to someone else, then A. Dave, the owner of the servient tenement, automatically assumes the rights of the dominant tenement. B. The new owner of Bart's property assumes the rights of the dominant tenement. C. The easement lapses with the sale of one of the properties. D. None of the above. Correct answer is B. The new owner of Bart's property assumes the rights of the dominant tenement. A servient tenement is a piece of land that is subject to an easement, which is a right or privilege that the owner of one parcel of real property has concerning another parcel of an estate. The owner of the parcel that benefits from the easement is called the dominant estate or dominant tenement, and the parcel that is subject to the easement is called the servient tenement. When Bart sells his property, dominant tenement, the easement appurtenant automatically transfers to the new owner. They inherit the rights granted by the easement, such as access or use of Dave's property, servient tenement. If it had instead been an easement in gross belonging to Bart, or personal easement, the benefit would indeed have ended with the sale of Bart's property to a new owner. Question 336. Real estate advertising is governed by rules created by all of the following, except A. The California Advertising Board. B. The Truth in Lending Act, TILA. C. Real estate law. D. Regulations of the Real Estate Commissioner. Correct answer is A. The California Advertising Board. California Advertising Board is not directly involved in regulating real estate advertising. It focuses on general advertising standards and licensing for businesses engaged in advertising activities. Real estate advertising is subject to a combination of federal and state regulations. 1. Real estate professionals must comply with the specific advertising rules established by their state real estate commission or licensing board as real estate law or regulations of the Real Estate Commissioner. 2. Additionally, federal laws like TILA might impose disclosure requirements for certain aspects of real estate advertising, particularly when it involves financing options. Question 337. Under the California Civil Code, if a broker was showing real property to a prospective purchaser where someone had died 5 years earlier, that fact would be considered A. A material defect required to be disclosed. B. Not required to be disclosed. C. A material defect but only required to be disclosed if the death was non-accidental. D. Any of the above, at the discretion of the broker. Correct answer is B. Not required to be disclosed. Based on California Civil Code Section 1710.2, specifically addresses the disclosure of deaths on real property. It states that a seller or their agent is not required to disclose the fact that an occupant of the property died upon the premises or the manner of death where the death occurred more than 3 years prior to the date the prospective buyer offers to purchase, lease, or rent the property. In this scenario, the death occurred 5 years earlier, which is beyond the 3-year disclosure period specified in the California Civil Code. Question 338. The Uniform Commercial Code, UCC, requires a notice to creditors of a business that is making a bulk sale must be published at least before the sale is transacted. A. 1 day, B. 12 days, C. 1 month, D. 3 months. Correct answer is B. 12 days. Under the California Uniform Commercial Code, specifically Division 6 concerning bulk sales, the notice to creditors of a business making a bulk sale must be 1. Published at least 12 business days before the date on which the bulk sale is to occur. 2. Given to the county tax assessor in each county in which the property to be sold is located at least 12 business days before the date of the bulk sale. 3. Delivered or sent by registered or certified mail to all known creditors of the seller at least 12 business days before the date of the bulk sale. Therefore, the publication requirement aligns with the other notification requirements at a minimum of 12 business days before the sale. Question 339. In an option agreement, consideration refers to the A. Appraisal of the optioned property, B. Optionee's promise to try to purchase the optioned property, C. Something of value conveyed by the optionee to the optioner for the right to purchase the optioned property, D. Past services rendered by the optionee to the optioner. Correct answer is C. Something of value conveyed by the optionee to the optioner for the right to purchase the optioned property. In contract law, consideration is something of value exchanged between the parties that creates a binding agreement. It can be a promise, an act, or forbearance, refraining from doing something. An option agreement grants the potential buyer, optionee, the exclusive right, but not the requirement, to buy a property from the seller, optioner. This right is valid for a specific timeframe and at a previously agreed upon price. The consideration in an option agreement is the payment or something of value that the optionee gives to the optioner in exchange for this exclusive right to buy. This payment is typically non-refundable, even if the optionee decides not to exercise their right to purchase the property. Question 340. Alleged violations of the real estate law are prosecuted by the A. FBI, B. California Secretary of State, C. Local district attorneys, D. Both A and B. Correct answer is C. Local district attorneys. The FBI primarily investigates federal crimes that cross state lines or involve federal agencies. While real estate fraud can sometimes involve federal offenses, e.g., wire fraud, mail fraud, the routine prosecution of violations of the California real estate law falls under state jurisdiction. The Secretary of State's office in California primarily deals with corporate filings, elections, and notaries public. They do not typically prosecute violations of the real estate law. The California Department of Real Estate, DRE, now known as the Bureau of Real Estate, CalBRE, investigates alleged violations of the real estate law. If their investigation uncovers evidence of criminal activity, they typically refer the case to the local district attorney's office in the county where the violation occurred. The district attorney then has the authority to prosecute these criminal violations in state court.